All right, we got some news out of the United States Supreme Court. As many of you are aware, the Supreme Court is reviewing a case as to whether or not being a habitual marijuana user is grounds to remove your right to bear arms under the Second Amendment to the United States Constitution. So the Supreme Court heard the case. Some interesting questions, kind of have a unique mix out of this. You seem to have some of the conservative justices pushing back against supporting the DOJ's position that habitual marijuana users should not be permitted to possess firearms or even ammunition. An interesting line of questioning came from Justice Gorsuch, who looked back to the history of firearm regulations to the time of the founding of the United States, which is appropriate, and they looked at some of the things like what determined a habitual drunkard, and then pointed out to some of the alcohol consumption practices of some of the founding fathers, many of whom drank 3 or 4 glasses of wine a day, others who consumed a pint of whiskey a day and considered themselves to be very minor alcohol users. So the questions are whether or not one of the founding fathers who had that type of alcohol consumption would be considered a habitual drunkard, and whether or not that argument would track here for people that use marijuana 1 or 2 times a week in states where it's legal. We won't know, of course, how the court decides until the opinion comes out, but nevertheless, interesting arguments and interesting responses from the justices. Stay tuned, and hopefully we'll hear back on this soon enough.